Hi guys, it's Kathy. I hope you're doing well. We made it to Saturday. A rough day yesterday. Rough. Bad news. Came down. Oh well. If you missed my live stream yesterday, Ralph Menzies' execution was vacated by the Ohio Supreme Court. They're going to make the district courts give him another competency evaluation. So with that happened yesterday. But we're in the weekend now, so my heart breaks for his family. But at least, he's in jail. He's not hurting anybody else. Doesn't help them. Nothing helps them. But, all right. I know I played Judge Devlin before from Colorado, but it's rare. It's not often that I play Judge Devlin. But he's such a good judge. So, we're going to start with this guy. This guy. He goes on a rant, and you're going to love it.
Okay.
They're pondering. There we go.
Behalf of Mr. Lawson, who appears in custody of Department of Corrections.
All right. This case is I believe, remains in probation revocation posture. Question the court has is, it looks like Mr. Lawson revoked his own bond on June 27th of 2025. So the question in the court's mind is, at what point is Mr. Lawson going to enter an admission due to the fact that it's likely—
That will be today, Your Honor.
Okay. The fact that he's going to probably very soon serve the maximum possible sentence on this case. Is that fair?
I think so.
Okay. All right.
So yes, we are prepared to admit to violation of probation the count contained in the complaint filed on March 17th, 2025, alleging new law violations. Mr. Lawson has now pled guilty and been sentenced in 25M1152, which I believe is a per se violation of his probation. Here, we are admitting that open to the court and asking to be resentenced.
All right.
I guess additionally, pursuant to Rule 11, Mr. Lawson has been advised he makes this admission knowingly, voluntarily, freely, and intelligently.
I mean, frankly, I think it actually might be moot given that he pled guilty to the new law violation. All right. That's the Arapahoe County case?
That's right.
Okay. 25M1152.
Mm-hmm.
All right. Take a look at that one real fast just to make sure.
Don't worry, we're going to hear from him soon. He's unbelievable.
All right. Looks like Mr. Lawson did indeed on August 8th enter a guilty plea and receive a sentence to 180 days county jail on the Arapahoe County matter. That's case 25M1152. Mr. Lawson signed and entered a guilty plea in front of Judge Stewart and was sentenced to 180 days jail or work release, 140 days credit concurrent to his other Arapahoe County cases, 19 CR 3980 and Douglas 23 CR 226, which are the cases on which he's, I believe, serving Department of Corrections sentence. All right. Court finds that does constitute a per se violation of his probation in this case, rendering his admission moot, although the court does accept his admission knowing that. And I think we can proceed to immediate sentencing on this matter. This is a class 3 misdemeanor. And given the constraints of the fact that Mr. Lawson is in the Department of Corrections on other cases, it ties my hands slightly as far as what I can do with Mr. Lawson's case. What's the people's position on sentence?
Yes, Judge, we are asking for the full 6 months of jail. Given that his VPO in Arapahoe is the same victim as this case, I did speak to the victim recently. She is very frustrated and very scared with all these cases that have been racking up. And given the nature of this case, which give me one moment while I pull up the facts. But the facts of these cases are that she was receiving death threats from Mr. Lawson. So she, just given that there was a recent VPO with Mr. Lawson and Ms. Jones, we would be asking for the max sentence of 6 months. He does have credit since June 27th, so we would be asking for that credit to be accounted for, which is about 60 days roughly. But otherwise, we are asking for the max sentence given the nature that this keeps occurring between him and Ms. Jones.
All right. Ms. Graves, position on sentencing?
Yes, Your Honor. The gist of my argument is that I'm asking for credit for time served, but I'll briefly take you through the history of this case. On November 21st, 2022, Mr. Lawson was detained. He then bonded out 3 days later and has 3 days of credit from that time period. Then in March of 2023, well, technically on bond in this case, Mr. Lawson is detained in Douglas County on 23 CR 226.
Yep.
On August 17th, a few months later, roughly 5 months later, he's then sentenced on this case to 24 months of probation with 180 days suspended. From that point on, and from the beginning of his probation sentence, Mr. Lawson has not been out of custody and not had the ability to basically comply with probation. However, he was on probation and so not on bond in this case, or not detained on a warrant and not technically given credit for that time. However, I want the court to know this, to kind of, in the spirit of recognizing he's now been in custody for 744 days straight, fashion a sentence that ultimately works out to be credit for time served. So then he continues, and 7 days after being sentenced to probation, here is sentenced to the department.
Kelly, thank you so much. Thank you so much. I appreciate it. Yes. I don't know when I start yet. I thought they would reach out to me yesterday, but they didn't. So now I'm going to have to call them on Monday. Say, let's go, people.
Of corrections on that Douglas County case. The warrant in this case then issues on January 1st of 2025. Once again, while he's still in custody, I think that's when the substantial nexus begins. And he posts bond on February 11th, 2025, in hopes that he might soon become parole eligible. Although he's parole eligible, he's not yet made parole. And so there's 42 additional days of credit between January 1st and February 11th, 2025. And then recognizing that he's not going to make parole on June 27th, he finally gets counsel. and we self-revoke his bond. And so that's 64 additional days. So by law and, satisfying the substantial nexus test, I believe he has 109 days of credit. In consideration, then he has been in custody for 744 days straight. I'm asking for a credit for time served sentence.
Okay. Now, you're not going to know this, but the case in front of the judge right now is DUI. Like, another DUI. I don't know how many were before it, but he's here because he got another DUI, and that's why he is in jail. You're not going to realize that till later, but now you'll know when you hear him rant. Means absolutely nothing. Nothing means nothing.
Mr. Lawson, anything you want to say?
Excuse me. This has been a very difficult, hard journey for me. Excuse me. Me and Miss Jones share a child together. His name's Bentley. He's age 9. He's on the spectrum of autism. So we've had our ins and outs, but every time something goes down, she goes and grabs a protection on me to keep me away from our son. I probably haven't handled it the best way. I know my son needs me. I have talking parents conversations with Miss Jones lately. The last time we did, she tells me how he's struggling with his autism and how bad he needs me. And finally, I get a chance to talk to him after about 2 years, and he's like, "Daddy, come get me." It's been hard. It's hard to deal with somebody like this because I know my son needs me. For 2+ years, I've been trying to get any phone call I can with him. I found motions, and she's taking protection orders on me, takes them off, puts them on, takes them off, puts them off. And I always have to take her back just so I can be with him. And right now I'm working with Child Protective Services, Arapahoe County Courts. I'm working with anybody I can just to get to my son. And I feel like these protection orders are being used to block me from. She'll tell me he has problems and like dangle a carrot in front of me, and then like go cross that imaginary line to help him. I get in trouble for it, and every time I try harder, I get in more trouble. And everybody keeps telling me to keep trying. And I have to stay in jail longer and longer. And I got denied parole this time because this incident. And like I said, I probably haven't handled it the best way. But it's been 2.5 years total since I've been locked up. And I've probably talked to my son 2 separate times in back-to-back days in maybe into February or March of this year. And I begged her for phone time. I begged her to let me talk to him. And she just tells me to call back at 6:30, and I call every day and she don't answer. It's the same game every time. And I don't know what to do. I don't know how to handle this as a father. I've lost everything. I was sober 3 years until this night I got this DUI. And I've been locked up ever since that day. And it's been the worst 3 years of my life. It's been so hard. And so I don't know when it's going to stop. I don't know. Maybe I'm not doing it the right way. I'm trying to get the proper legal assistance and help, phone calls, anything. I'm just trying to do anything I can. I don't know how much longer I'll be here. Hoping not long. I've done everything I can. I've been programming. I've taken mental health classes. I don't know what else I can do. I'm at my end. Just have had enough. That's about it.
All right. Well, Mr. Lawson, I did, for the record, I'm very aware of all your other cases. When I was going through my docket on taking over this position, I read every single one of your cases in the state of Colorado in preparation for whatever was going to occur on this one. I'm going to call where you're at right now, hopefully rock bottom for you. You're in prison. You're in prison and very ironically worried about misdemeanor violation and protection order cases and being able to see your son when you're in prison for sort of unrelated reasons, which is that you just can't stop getting DUIs. I've read those cases too. I read your motions to reconsider in the Arapahoe County case and the judge's orders afterward. I've read the Douglas case. I'm also aware that I believe you're also a victim of a DUI crash at one point that actually hit you, if I remember correctly from the facts of your case. But
Actually, Miss Jones was I was the victim because I was the driver. Oh no, I was a passenger while she was the driver. But
He's got so many DUIs he can't remember which ones he was driving for and which ones she was driving for. And he got hit by her. He got hit by her. I don't know. I don't know if it was on purpose or by accident, guys. We don't know. I'm guessing on purpose. That's just my guess. Micah, I'm so glad that I was muted when you walked in. Hi, Micah. Not excited at all that you're back. I didn't even realize you were gone. Not even a little. Right, guys? Micah, are you home now?
I was also ran over by her and her ex-boyfriend after I got a
right, that's right. I do remember that now.
They tried to take me out.
Thank you for refreshing my recollection on that.
Yeah,
I do remember that. That was like an Inglewood incident, right?
Yeah. I
Okay.
just got a protection order and it lasted
You
about
have that
30
right.
seconds.
Yeah. So, Mr. Lawson, your criminal history is entirely characterized by way too many DUIs, and a whole bunch of stuff like this with misdemeanor domestic violence and protection orders and the consequences of those protection orders. And I just hope that where we are right now, hopefully that's the end of it. Hopefully that's the bottom. I worry that it won't be, but that's on you to solve. You're gonna have to solve all.
Judge, did you just not hear him at all in the last couple of minutes? He doesn't give a blank about his DUIs that he's in jail for. He doesn't care about that at all. He doesn't care that he's violating protection orders because it's all her fault. His DUIs are apparently her fault, and she's an ex.
All these issues as you try to rebuild your life when you get out of prison.
Yeah. Totally correct.
All right. That being the case, Ms. Graves, could you go over for me the substantial nexus test and the amount of credit that you're claiming against that? Because as far as I'm concerned, it's June 27th to now, and then the 3 days, but there's some additional time that you're claiming.
Yes, Your Honor, I am requesting an additional 42 days. The substantial nexus test basically asks, but for the underlying sentence that he's in the Department of Corrections, would he continue to remain in custody? And from the time period when the complaint for revocation of probation warrant was issued to the time that he posted bond, he was being detained on a warrant. And so, So it's
essentially the fact that DOC doesn't independently execute those warrants.
That's correct.
Understood. I will grant Mr. Lawson those additional days of credit. So that's a total of 109 days.
That's correct, Your Honor.
All right.
Thank you.
Mr. Lawson, as far as I'm concerned, there's really no other option. I'm going to sentence you to the 180 days. The 180 days was suspended over you upon successful completion of probation in this case, and you didn't successfully complete the probation. Now, it was smart to self-revoke your bond. The only way I could possibly sentence you to more time, which might be tempting in a different context, but the only way I could is by ordering it to be consecutive to your DOC sentence. But in order to do that, I would have to order that you serve the jail first, and at the moment, I can't do that. So I'll order you to serve 180 days in the county jail concurrent to your current DOC sentences on the 19 CR and 23 CR cases from Arapahoe and Douglas, respectively. You'll be granted 109 days credit for credit for time served against the 180 days, and the sentence may be served in DOC. All remaining fines and costs and other expenses will remain due, but upon completion of the jail sentence, this case will be deemed closed.
Thank you.
Any questions from the parties?
No, Judge, thank you.
Your Honor, I just asked that it also be run concurrent to 25M 1152.
Okay, so ordered.
Poor guy. I feel so bad.
All right. I think that is all for Mr. Lawson's case. Appreciate DOC for accommodating the writ.
No, I didn't. No, I didn't. No, I didn't. I don't even know who's going. Mike, I was so glad that you're back. I'm so happy. Court vibes. The whole court vibes chat is better again tonight, guys. Okay. We're going to stick with this judge one more time. But this one, there's no freakouts or anything. It's just really cool. Interesting.
So, here's my issue on Mr. Ya's case. We'll go on the record.
Okay.
Case 20T 460, People versus Kai Ya.
All right. Who else just heard Uncle Rogers in their head? Who else did? I keep hearing it every time I play this clip. Hey, yeah.
Alexa Lopez for the people.
Natalie Graves from the Office of the State Public Defender on behalf of Mr. Ya.
All right. So the parties have presented a plea agreement while I was waiting for that. And since then, I was doing a little bit of research on judicial recusals. So there's a case, Williams versus Pennsylvania, decided June 9th of 2016 by the United States Supreme Court, 579 U.S. 1. The holding in that case.
Uncle Rogers, it started basically with rice. This is how you make rice. This is the correct way to make rice. And he would watch videos on other people making rice. And it was bad. Bad. And hi-ya. Every time they do something that he doesn't like, he says, hi-ya. Well, then he got bigger and bigger on social media, and he started doing other dishes. And then he started critiquing Gordon Ramsay, Rachel Ray, Bobby Flett, just chefs. He would get chefs who said that they would make this dish, and he would watch them and say, hey, yeah, that's not how you do it. He's so good. Uncle Rogers is just high quality content. High quality. Nobody has seen Uncle Rogers. That's crazy. He's very freaking popular. I mean, CJ, I understand that, and I should have said more. But no one else has seen Uncle Rogers. He's really good.
Which appears to be sort of directly applicable to our current situation. Let's see.
If it's helpful, Your Honor, we're not asking the court to recuse.
Oh, I know. I just. Yes, according to Williams. The court in Williams holds that, and this is, again, U.S. Supreme Court, the court now holds that under the Due Process Clause, there's an impermissible.
They made a show about him. He has his own TV show now. I just saw season 1, episode 1. But this was 4 years ago. I just looked at his video. His last video got 18 million views 4 years ago. He's just really good. He's just very funny.
risk of actual bias when a judge earlier had significant personal involvement as a prosecutor in a critical decision regarding the defendant's case. That's the holding of Williams. Now, the Williams case is a death penalty case, so obviously we're dealing with a dramatically less serious set of facts here. But I went back through Mr. Yah's cases, and I remembered actually at that time that there were cases. Mr. Yah was a juvenile when these cases were originally filed, and I took a look through the court file. I filed both of these cases, or at least both of them were filed at my direction. The 20T case, the one we're calling currently, is a summons that was issued to Mr. Yah, actually, again, at my direction, because Mr. Yah fell into that kind of strange time period where he was eligible to be charged as an adult, and in fact actually could only be charged as an adult under Title 42. After we filed the juvenile case, which was a vehicular homicide with the exact same fact pattern as this matter, I directed State Patrol to serve him with a summons for the Title 42 offenses that had to be charged via summons in county court. I also went back through the two court files, and my signature as the prosecutor is on both plea agreements, the juvenile case as well as the T case. So my concern is less that I would necessarily be subjectively unfair to Mr. Yah, but my concern is that under the Williams case, I'm not really sure if I have a choice but to recuse from this case, given that I was the prosecutor all the way through sentencing on it. And I have significant knowledge of the facts. I had to refresh myself on them, but I do remember this case quite well. And I did handle it through basically every stage. The only stages of it that I haven't handled are the recent probation revocation, which now comes back before the court. The understanding that this is a dramatically less serious case than the Williams matter, I don't find that the Williams case is materially different in its the holding in the Williams case is inapplicable to our current situation. It seems to be actually directly applicable to our current situation. There are also no federal state issues. The Williams case arises out of a state prosecution, similar to this one. But I think under the Williams case, there are many cases that are going to appear on this docket that may or may not have had my involvement in much less serious portions of it. Like maybe I filed it, but it went into a failure to appear status for years. And then I think I can adjudicate those cases. I don't think I can this one, just simply because I determined what the plea offer was. I determined what the probation conditions were going to be requested by the people in this case. I think under the holding of Williams, despite the fact that I think I could be fair to Mr. Yah, I think it would be inappropriate for me to be the one that adjudicates this case when I was the accuser, as the Williams case pretty clearly holds. So I am going to issue an order of recusal on this case. Mr. Yah, I apologize, this is going to result in a little bit further delay of your case, but I wouldn't do this if I didn't think it was legally required for me to do it. I think, for example, I don't think this isn't going to be a whole bench recusal. Miss Judge Slade, I think, was already on the bench far before this case was filed. I think it would be easy for her to substitute in as the presiding judge in this county to deal with Mr. Yah's case. So I think that's probably what I'll inform the chief judge I'm going to ask for. Does that make sense to the parties? All right.
It does, Your Honor. However, we just have a sort of practicality concern in that Mr. Yah, under this plea, is prepared to begin his sentence today, has been dropped off with no return ride. And as such, we are hopeful to continue to plea and sentencing today, if at all possible. I don't know if there's another judge in the district who might be able to hear this case.
I can certainly ask.
Thank you.
So,
We're going to find out in a second. It's 4 o'clock. They're looking for another judge at 4 o'clock.
let me see if I can find one.
Because
It's right. Just walk over and punch the guard.
Yeah, and unfortunately, I don't even think this is the type of
No, they won't send you to jail for that, will you? Will they? They won't. They'll just say, don't you do that again, or else.
conflict that's waivable. Does that
I
make sense?
understand. Yeah.
Yeah.
Yeah, you get a finger wag. Yep. Hey, Floor. I don't know if I would be happy or sad if I was supposed to go to jail today. And the judge says, well, I can't let you go to jail today. No, no. He's not pondering. He's texting. All right, Kelly. Thank you. I will look at that. That's what he's doing. It's almost over. He's almost done. I should have cut this part out. Now that I think about it. I just don't have time. When I'm watching these videos and getting them ready, I don't these long pauses I don't pick up on. I have to force myself to figure out if there's a long pause. I don't want to pass it. I know it's not long. Alright, I'm going to try. Bump it ahead.
Worst case, Miss Graves, I suppose what is theoretically possible is if Mr. Yaw wants to self-revoke his own summons, and we could try to set it on like Monday for another judicial officer.
Oh.
You know what I'm saying? Just because it's like 4 p.m., I anticipate next to no nibbles on this, but
The judge is wrong there, guys, and it's something that you need to realize. It's the courts aren't open on Monday. So if you get arrested today, you're going to be in trouble till Tuesday. So behave.
we'll see.
Okay. Yeah, that makes sense. Let's wait about 10:15, and then if not, we can.
I'll also go call Judge Slade. I know I'll just call her on her cell, and worst case, what we could do is what I proposed, and then have her deal with it on Monday, or have Mr. Yaw come back on Monday. Either way.
Monday is a holiday.
Oh, that's right. It is.
Hi,
Oh,
guys.
if we could do Tuesday.
Judge Bowling's offered to take it.
Okay, that's fine by me.
Yep.
Does he want the parties to log into his courtroom?
Yes, he
If-
does. I'm going to send.
If Judge Bowling streams, he won a special place on my stream Wednesday morning because I mean he's not going to stream again until Tuesday because it's a holiday. But I am going to shove him in. If he streams on Tuesday, I'll show him Wednesday morning because what a great guy.
Him just a quick note, and then we'll be good.
Okay.
The note will not contain any recommendations. I'm just going to give him a slight bit of background
Fair
since it's a complicated matter.
Office and appear virtually in front of another judge who will make the decision, okay? Thank you, Your Honor. I appreciate your flexibility.
This is a new judge, not new to us. He is new to us. We've seen him once or twice before, but he is a new judge.
Flying Flamax. Yeah.
All right, good
Yeah.
enough. Good enough.
It's a
Good
good
enough. Good enough. We're gonna move on. This audio is either going to work or not. That's all I can say. We are either going to see this judge in Texas or we're not. She's so good. I really love her. We're not going to see crazy parents. It's a custody case. No, that's not what you call it. What do you call it when your children get taken away from you and you're trying to get them back? Not a reunification. It's a parental. Not parental custody. Guys, I can't find the word. Lori's here too. Oh my God. All right. Whatever that word is, just fill it in your head. That's what we're about to watch. And either the audio is. Here we go. I'm nervous. There she is. She's so good.
Okay, this is a hearing. Jordan's with the foster mom. He's been determined that he has some diagnosis and he's gonna need services for a long, long, long time. But foster mom's helping him. He kind of goes through spells where he has tantrums and doesn't have tantrums. Evelyn's with the paternal grandma. I'm very, very, very disappointed with the violation of my court's orders for multiple reasons. I'm upset with grandma. I'm upset that mom allowed these things to occur when she knows better. And don't give me, I didn't know because I'm not buying it. I've been through this 3 or 4 times. Fortunately, the kids are Evelyn's doing good. George's doing well. I'm going to order that nobody is to pay any of the parents' bills, rent, give them gas money, etc. They've made this bad. They can figure it out themselves. I'm tired of people trying to help them out. And if they want their kids returned, then put their money where their mouth is and show us.
Whoa. That's not the right word, Kelly. I mean, it is the goal. The goal is reunification. That's not the right word, though. There's a word. And it'll hit me. It'll hit me in like 3 hours when we're done streaming. I'll be like, oh yeah, that's the word. That judge. Do not help these parents. Don't you dare give them rent money. Don't you dare give them gas money. God. No. It's.
Do it. So that's going to be in order. And Mr. Wilson, or I guess it's your case, you may begin.
It is my case, Judge. Thank you. Good morning. Can you all still hear me? Okay.
Yes, sir.
Disappeared for a second. Good. So regarding what you just said, Judge, the department's disappointed too. There does seem to maybe be, we're not making excuses, but maybe some extenuating circumstances. We're a little worried about this placement holding and need to find some ways to maybe give that grandmother some respite or some breaks or something to help kind of keep things together till we get to the end of this case in a few months. The case is going okay. Mom seems to have possibly turned a corner and is providing lots of certificates and things that she's done. She's notwithstanding those visits, she's doing what the department expects her to do, what she's supposed to do. And we're getting hopeful that we're going to have a positive end to this case. Apparently, we've had a recommendation from mom's therapist to begin some unsupervised contact, so that needs to get talked about.
No, I'm just gonna tell you right now, I don't wanna hear it because she's been having plenty of unsupervised contact that was not court ordered, so I don't wanna hear it. I'm not doing
Right.
that. I'm
Okay.
mad. I'm not doing that right now. No, absolutely. I mean, does the therapist know that the order violated about multiple times? Probably not.
Yeah, probably not. I don't know that, Judge.
Yeah, no,
Yes,
not
ma'am.
happening. Not happening.
All right. Well, I think that's where we're at today as far as the department's concerned. We just need to keep the wheels on and keep these orders complied with and keep moving forward.
I mean, I think the rest of it is a good idea. I don't know who that could be though, but we can talk to everybody about that.
Okay.
So, okay, thank you, Mr. Wilson. Do you need any witnesses?
I don't think so. Ms. Dela Cruz is here. If anybody wants to hear from her, I'm sure there'll be something she needs to tell us about or chime in on at some point. But in terms of taking testimony from her, I don't plan to do that.
Okay, thank you. Ms. Wright?
Judge, I would call Marcy De La Cruz.
Okay.
Ms. De La Cruz, can you tell us what additional things mom is doing at this point on her own?
So, Sydney Lewis has sent me some screenshots of potential classes that she's taken. On these screenshots, it says that she would have to pay for the certificate. But,
Kelly, thank
in
you.
the screenshot,
Thank
it
you.
says that
Thank
she
you.
has, there's a certificate for foundations of autism awareness and support, introduction to autism awareness and support, autism spectrum disorder in early childhood, and I believe one other one, children with autism in school environment.
But wait, there's something special about these certificates.
I've asked her to send me her payment history for like her rent, and I've asked her to send me
No, I'm
NAAA law.
talking about the actual name of the hearing. It's I forgot that I forgot, and now I remember I forgot, and now I'm thinking about it again. This type of hearing is called a something, and I can't. The word is escaping me.
Worksheets, the pay that she gets from her employer, and her like sobriety goals and things of that nature. And so she has sent me a list of all these things. I have shared that with the ad items this morning. But she, we're next thing we're going to discuss is doing some financial planning.
Okay.
So
at this point, has she done all the services that the department has asked her to do?
to my knowledge, yes, she's still working with her therapist, which will be ongoing.
Okay. And
She's testing.
Do you have therapy records?
I believe Deb Tabor just emailed me something, but she hasn't sent me a whole lot of records. We've talked on the phone.
Okay.
Mhm.
And your attorney said her recommendation was to start some unsupervised visits, correct?
Yes, ma'am. I'm looking at it right now. It says I'm recommending that Sydney Lewis have unsupervised contact with her children. She's maintained her home employment and has been consistent on her therapy and all of her visits. Please contact me if you have any questions regarding therapy services and this recommendation.
Okay. And was Ms. Tabor aware of these unsupervised visits that took place?
I'm not sure. I can't remember if we discussed that or not.
And can you tell us how many unsupervised visits took place? Unsupervised, unauthorized, I guess I should say.
To my knowledge, 2. They were over 2 weekends.
Okay. And was it the whole weekend? Was it a day? What did that look like?
From what I understand, it was Friday to Sunday.
Okay. And do you know when those took place? Like what month?
I don't. I really don't. It was prior to me being on this case. And I wasn't informed of what dates.
Okay. And to your knowledge, how is the child doing?
I think she's doing well. She's a young 8-year-old girl who's gone through some trauma that, back and forth from placement to placement and things of that nature. This is her 3rd time in CPS care. But, so she has some defiance things, but other than that, I think she's doing well.
Okay. And do you think at this point it would be appropriate for Miss Lewis to start, helping transport the kiddo to therapy, things like that?
Yes.
Okay. And do you see any danger in starting that?
No danger per se, no.
And let's talk about Jordan. So what are his diagnoses?
Autism, and then he has a developmental delay.
Okay.
Global developmental delay.
And has mom been allowed to be in any of those doctor's appointments or things to learn about his diagnoses?
Not to my knowledge. No.
Okay. Do you think that would be appropriate for her to learn about what's wrong with him
Yes.
and how to deal with that?
Yes.
And do you think it would be appropriate to find mom some sort of autism parent class or something? I mean, that's kind of what she's trying to do on her own. Agree?
Yes. Yes. And I have sent her some resources that she's looked into. Baylor University has one that's virtual. And I sent her 2 others as well. So we're definitely working on that.
Okay. And then the bottom line, if this placement falls apart, there's nowhere else for this child to go as far as family, correct?
That's correct.
And that's why Jordan is in foster care, correct? Because there's no other family to take him.
Yes, ma'am.
Okay. Your Honor, I pass the witness.
Anybody have any questions of Stanley Cruz?
Yes, Your Honor, I do.
Okay.
I think what the word I was looking for might have been permanency. CJ, that might have been it.
Starting with the certificates, Ms. De La Cruz, when did you receive those?
Let me look.
Well, I just was it past couple of days or what?
Yeah, it's just recently. Over the weekend, I believe is when she started taking them.
And you just sent those to us about 5 minutes ago, right?
Yes, ma'am.
Okay, and it says on it that it is a sample certificate, is that correct?
Yes, ma'am.
So you have no way of knowing whether or not she actually took the course, since usually you have to pay for a course before you take it, right?
She sent them sample certificates of all these courses.
Don't know. I mean, there is one screenshot.
Okay, well, wouldn't you prefer to have the official certificate so that you know a client had actually attended something?
Yes, these certificates are costing $30 a piece, apparently.
That's what courses cost, right? So you did a course, you pay for the course, correct?
I would think so.
Okay, so we don't know for sure that she actually attended these because what we have is a sample certificate, correct?
Yes, ma'am.
Okay, so on the next issue as it relates to rent, I want to talk about that a little bit. Isn't it true that Mrs. Spray has paid on a number of occasions rent for Miss Lewis? At least according to Miss Spray.
I'm aware of at least 1 month. And I believe
Judge
she's
doesn't like
helped
that.
previously, is what she's told me.
Okay, have you asked for an accounting for that for the full time that Sydney's been there?
I have. And
Have you received the full accounting? I know we have 3 months, but have you received it for the full time she's been there?
so I haven't received it from Miss Spray yet because she needed Sydney Lewis's approval. And so I had reached out to Sydney and asked her, and she said she would be fine with giving that approval. Not sure if that occurred, but Sydney did send me her list a list that she has of all of her payments.
Okay, and I'm looking at that list and on 7/15/25, I'll give you a second to pull it up. It says she got a payment of $773 for like a welcome home, kind of a free upfront payment. Is that correct?
Yes.
And then it also says she got a move-in special for $900, and it was a concession for the flood. And that was in July. So her July rent was paid with flood money from the apartment complex, correct?
Yes, ma'am.
And so that would have been something that Mrs. Spray arranged for her to have, so she'd have free rent that month,
I believe so.
even though there was no flood damage. Is that correct?
I don't know for sure, but I think, I don't know that they had any flood damage.
Okay, and then in June, there was also another welcome home payment for $963, which looks like it was comped as well. Is that correct?
Well, I don't know what the welcome home card payment is, to be honest with you.
Okay, I'll ask Miss Spray. But as far as you know, she's received money for flood concessions and she's also received money from Miss Spray. So we are unable to determine what her financial stability would be. Is that correct?
Yes, ma'am. That's
Has
correct.
Miss Spray also indicated to you that Sydney does not stay at the apartment complex? She doesn't see her there very often?
Yes, Sydney has actually shared that with me as well.
Okay, so Sydney pretty much lives at Johnny's house. Is that correct?
She stays there from time to time.
Okay. And then in terms of it not being a danger for Sydney to drive Evelyn, I wanted to ask you a couple of questions. When you went out and visited isn't it true that what Monica indicated to us was that, or Miss Spray, was that Sydney took Evelyn, the little girl, to Johnny's house, her sister's house, and let her stay there for the weekend? Is that what you recall?
Yes, ma'am.
Okay.
On one occasion, I believe. Yeah.
Okay. And we don't know where she was on the other occasion?
No.
Okay. And did she indicate to you or to one of us what the condition of little Evelyn was when she returned, physical condition?
I recall someone, I don't think that Miss Spray actually shared with me specifically, but that Evelyn, I guess, returned dirty, maybe disheveled. Yeah.
Okay, you remember something generally about that.
Yes,
When,
ma'am.
when you went and visited Johnny's house to, take a second or third look at whether or not she could be appropriate placement, who did you go with?
Flag, hell.
Okay, and can you tell me what you saw at the home?
Upon arrival, there, I believe it's her husband, Johnny's husband, was there with the kiddos, and we saw what I recognized that stood out the most was a couple trash cans that Johnny said, hadn't been taken out in a while because the trash man, whatever, but there was beer cans overflowing. There was two beer boxes at least laying on the ground in the yard, and then some beer cans kind of lined up and stacked up on a bench up near the house.
Okay. What happened? What did you see when you entered the home?
We were not allowed in the home. We were there unannounced, and they said they weren't expecting us, and we didn't enter the home.
Who was they?
Johnny, Sydney, and I guess Johnny's husband. I didn't really speak to him, but he was present.
Okay, and that's the home where Miss Lewis has indicated that Evelyn stayed. Is that correct?
Yes.
During one of the unauthorized visits.
Yes, ma'am.
Wouldn't you have some concern that that might be dangerous for Evelyn to be in that house?
In that house, yes, ma'am.
Okay, so, when she already violated one court order, what assurances would we have that she wouldn't take, if she was unsupervised, that she wouldn't take Evelyn back to that house?
I can't answer that.
Okay, so we don't have any assurance that she wouldn't take her back, and it would be a danger if she went there. Is that correct?
I believe so. I would limit the time frame, and I would only allow her to transport Evelyn to visits to see her brother, and certain things of that nature, not giving her enough time to actually take her over there until we were able to trust that she could follow the court orders.
But we don't know. Well, she can't follow court orders. Clearly, she just violated them. So how are we? You see why I'm saying that could be dangerous. I'm going to move on. Isn't it true that Monica also allowed Evelyn to see Mr. Oliva?
I believe she shared that with you, and you shared that with me. I'm not sure. Monica's not shared that with me.
Okay. Judge, I think that's all from Ms. David Cruz right now.
Okay, thank you. Mr. Grove, any questions?
Judge, as much as I would like to explore free rent payments and a beer party in violation of court orders, in the interest of the court's time, I don't have any questions.
Okay, thank you.
Judge, I have just one couple more follow-up for Ms.
Okay.
Cruz quickly. Ms. Cruz, what assurances do you have that the placement's going to follow the court orders?
I guess it's the same response. I don't know.
Right, because this wasn't just mom, right? I mean, the placement knew the rules, right?
Yes, ma'am.
And she also let the child see the dad. I mean, and he's in jail right now. So does that cause you concern?
Yes. I mean, it does. I do believe that Evelyn is well taken care of at Miss Spray's residence. It's every time I've been there, I've recognized Evelyn is clean and happy and healthy and getting her needs met. I believe before I took on this case, there wasn't a whole lot of, I don't know how to explain that, but I asked a lot of questions, and I found out that she's been struggling. Miss Spray has been struggling with needing help, needing more supervision. I've asked her for other family, other friends names, and I believe she has reached out to her family for help, but it would be even more beneficial considering Sydney lives in the same complex that Monica works at. Evelyn would be dropped off at that complex from the bus. I mean, it definitely is convenient for Miss Spray.
Okay. And isn't it true that the reason you found out about these unsupervised visits is because Sydney came forward? Sydney told me and I told you.
Actually, well, yes. Okay. When there was one day, yes, that Monica, yes, you're correct.
Right. And then you don't know as far as the home, whatever that home card or whatever it said. I mean, we don't even know what that is, right?
That's correct.
The only one we know that she gave her a concession on is the one that says concession, correct?
Yes, ma'am.
And that was for July 14th.
Yes, ma'am.
And I mean, to your knowledge, Miss Lewis hasn't been evicted, right? She's been able to pay her bills somehow, correct?
That's correct. She is late on a regular basis, and what I understand is she, uh, um, from what Miss Bray has shared with me, that if she is late anymore, that she could potentially be evicted.
Okay. Your Honor, I pass the witness.
Anybody else?
Your Honor, I had a couple of follow-up questions for Jordan.
Okay.
Ms. De La Cruz, I understand that Jordan has been very aggressive at his school, and it's my understanding from the foster parents that he may be getting close to having them discharge him. Is that your understanding?
Yes, ma'am.
Okay. And in that regard, they have requested a special school for him, which has about, it has more one-on-one, almost twice the one-on-one oversight for Jordan that they would like to place him in for his special needs. Is that correct?
Yes.
And can you tell me what he was diagnosed with? Do you recall?
Autism spectrum disorder and global developmental delay.
Right. And it was level 2 requiring substantial supports. Is that correct?
Yes.
Okay. So they are, is my understanding also that the subsidies, childcare subsidies are not accepted at that particular school or any of the others that they could locate. So the full amount would need to be paid. Is that correct?
That's what it sounds like. That's
Okay.
what they shared with us. Yeah.
Okay. So they're requesting that the department pay for childcare, which is appropriate for this autism level 2 child. Is that correct?
Yes, ma'am.
And it's my understanding it runs about the same as a regular childcare, it just doesn't get the subsidies.
That's what it looks like, a little bit more.
Okay.
But pretty close.
Pretty close. Okay. Do you feel like that there is a need for Jordan to have that specialized level of care?
Yes, ma'am, I do.
Okay. Do you believe that there may be continued disruptions at lower level daycares if we continue to move him around where they have the CCMS subsidy?
Definitely.
Okay. All right. That is all I have for Ms. De La Cruz. Thank you.
Okay. Anybody else?
Judge, I'd like to ask a few follow-up questions
Okay.
about that. Ms. De La Cruz, is there a particular school that they've asked for Jordan to go to?
Yes, sir, there is.
Have you checked out that school?
No, I haven't had a chance to.
Okay. Is it possible they
I
live?
see the volume of my microphone was popped down to 0 again. It happens. I don't know why it happens, but if I don't catch it, it's a 0. That's why you guys said muted.
Where do they live? Where generally where do they live?
They live in
Not too
Georgetown.
far, not too far from here. I was gonna say.
Okay. Well, depending on how close or how far, I guess, from Austin or that greater area, there may be options for schools, that school or other schools that might be appropriate for him as well. Is that possible?
I'm sure there could be other options.
Doesn't the department have a daycare specialist or liaison or somebody that can help?
Yes, they do. Yes. And I reached out to her and left her a voicemail.
Okay.
I plan to email her as well.
Okay. So the department's not taking the position that, no, this child doesn't need to go to this school. We just want to find the best fit with the budget we've got. Is that a fair way to say that?
Yes, sir.
Because we like it or not, we do have to be mindful of how much money we agree or we're told to spend. And we want the child to have what he has. I mean, have what he needs, but also need to find the best way for the department to make that happen. Would you agree with that?
Yeah, yes, I would like to just avoid any delays because I know that if we have to, I mean, if they don't accept CCMS, I'm going to have to send that way up the chain, and there could be some pretty significant delays there. And I just want to avoid all of that at any cost possible.
Okay. All right. I just want to make sure everybody knows you're on top of it and you're talking to that contact in the department about daycare and you're going to explore all your options. Is that what you're planning to do? Okay.
Yes,
Thank you. Pass the witness,
I
Judge.
like this
Anybody
guardian.
else? Ms. De La Cruz, have you seen if Miss Lewis's apartment had any flood damage from the big flood, water damage, plumbing, any type of flooding?
I didn't see any evidence of that. No, ma'am.
Did anybody tell you that there was any flood damage?
No.
When you pull, okay, what's the name of the complex she lives at? It's like Park Ridge or something.
I'm not sure. I'm sorry. I don't. I
That's
can't
what
remember.
it says. It says Park Ridge on this little
Okay.
thing.
When you pull into the complex off the street, you know what I'm talking about, Miss De La Cruz?
Yes, ma'am.
Which way do you turn, right or left?
Left.
Okay, and where does she live in relation to the highway? Does she back up to the highway or is she on like the other side? Or do you know?
I mean, she's not right on the highway. There's another, I think there's another complex in between her and the highway.
Okay,
Not complex, but a duplex, you know, a
yeah.
building.
okay. Did Miss Lewis tell you that she was getting a flood concession?
No, ma'am.
Would it surprise you that other people in that complex didn't get a flood concession?
Would it surprise me if other people didn't get one? No.
How does the judge know
How much
this?
was it? Do you know?
I believe it's 900, which is the amount of her rent.
And how much was the welcome home
900?
concession?
Judge, I don't think we're positive that that was a concession. We'd have to ask Ms. Spray.
Okay. What other kind of rent supplements or help has she gotten, Ms. De La Cruz?
Well, that I'm not 100% sure about. I don't see, I'm looking through the dates here and the amounts, and I see, let's see, concession or a move-in special potentially. No, that was the same one, sorry. I don't know of any others.
Okay. Why is Mr. Oliva in jail and not TDC? Do you know?
That I'm not 100% sure. He did tell me that he wanted to sit out the rest of his time on parole in county. That he couldn't do it in Kingsland where he was at. It wasn't the best situation for him.
Okay. Have you seen him since he's been in the Lano jail?
No, ma'am. I plan to go next week to visit with him.
So basically, you don't know what he's doing there, other than maybe sitting it out, right?
Correct. Yes, ma'am.
Don't you're used to the criminal system. I mean, you don't just pick and choose. Oh, I want to go to the Lano jail. Would it indicate to you that there must be some sort of holes or something on him?
Potentially, yes. I would have, yeah. I would like to look into that more.
Based on your past experience, why else would he be able to be in the Lano jail?
I mean, if he violated his parole, he'd go back into custody.
But he was already in TDCJ, right?
Yes. And he was released on parole from what I understand.
Okay.
And hot
Children
dogs.
let's just talk about Jordan because Evelyn's with family. Jordan is in foster care because none of the family has been cooperative in letting y'all do a home study. Is that correct?
Yes, ma'am. Yes.
Or none of them would pass any background checks. Is that correct?
Yes.
How many family members have not let you into their homes? Just a sister?
Yes, I've been told that the parents, the maternal parents would not allow us, but I hadn't attended that, but just the sister at this point.
So your knowledge, you got two sets of two different homes that won't let you into the house, correct?
Yes, ma'am.
What about grandparents? Sydney's grandparents is where she's hanging out most of the time, right? Or who's Johnny? Who's Johnny?
Johnny is her sister, is
Okay.
Sydney's sister.
Okay. What about Sydney's grandparents?
I'm not familiar with them.
Your Honor, if I might, Miss Andrea and I visited Julie Reed and her husband, but they later declined to take hair strands. And
Julie is the grandma,
maternal,
right?
maternal grandma. Her home was appropriate, but she didn't have a vehicle. Not sure if she had a driver's license, and they declined the hair strands in the home study.
What is the sister's name, Miss De La Cruz?
The sister that I went to go visit
Yes.
is Johnny.
Okay. What about, there's some great grandparents. Have you found out, you know anything about them?
I mean, we've done quite a bit of history searches. We've called many families, but honestly, I don't know who's who, but we've called many people.
Well, and I'm just throwing this out. One time, Sydney was with, not Sydney, Evelyn was with some people, I believe, named the Hazels. Have you talked to them?
Yes, I believe I have.
And Judge, if you recall, she was removed from that home.
Okay. I knew there were some issues, but I couldn't remember exactly what it was.
And then Miss Andrea and I did go to 2 or 3 other places that were provided that, we get one place who'd give us another name. And I think it was like maybe somebody that taught at the school and a couple other places. But we spent a whole day trying to visit homes one day. And I apologize, I don't have that list in front of me. It may be in my records somewhere. I know it's for sure in Costa's records somewhere, but we have looked extensively for relatives.
Okay. Okay, I think that's all my question. Oh, let's see. Oh, Miss Taylor Cruz, why is the grandma need help with Evelyn when she's been at the Boys and Girls Club or she's at school all day?
Well, so Evelyn has made it clear that she does not like the Boys and Girls Club. She cries. I mean, pretty dramatic with that. I don't know what the situation is there, but Monica has picked. She's allowed her to go half days and then taken her to her place of employment, the other half, just to kind of help Evelyn. And then now that school is in, they are out like every other Friday, I believe. And so that's what Monica is asking for is for this coming Friday, she's out of school and she's asking for some help there. So she doesn't have to take her to her place of employment or Boys and Girls Club.
Have you talked to like Alphabet Alley or any of those places?
No, I've not heard of that. No, ma'am.
Okay, write it down. I think that's the name of the child care.
Alphabet Alley.
Yes, Ludi. Miss Garnet, what's the name of the church? You think Miss Taylor Cruz can call the church Ludi's?
Ludi Watkins, yes, Judge.
Okay. Okay. My office might have some information for you on that. If you call Miss Garnet, she's filling in while Angelica's out. She goes to church there, and Mr. Wilson knows some stuff. And if you call Miss Garnet, she might have some other information for you too in my office.
Perfect. Yes, ma'am. I will do
County
that.
office might know too because they got grandkids and they got kids and they got all kind of church connections, everything else also. Okay.
Okay. Yes, ma'am.
Okay. Anybody else?
No, Your Honor.
Okay, thank you. Miss Wright, next witness.
Judge, I would call Miss Spray.
Okay.
Miss Spray, can you unmute yourself?
Hello?
All right, there we go. We can hear you. Miss Spray, can you tell us a little bit about the rent situation and the concession that was made?
So the flooding was since Cindy works cleaning homes like at an Airbnb. So a lot of the time that we just put into consideration that she couldn't clean houses because of flooding and people did not make the reservations. So we gave her that concession.
Okay.
Not because her apartment was flooded, no.
Okay. And then what about the payments? So I'm looking at like a screenshot of her, I guess what's Sydney's side of the payment app. And it says welcome home payment. What is that?
She pays online, so that's what it is. She
Okay.
makes payments online.
So the only help that what I'm looking at, the only assistance she's gotten is that concession on July 14th. Is that correct?
I think then in the moving concession, but that was it, which is the $900.
Okay.
So we have several of them that got that concession.
For the move-in special?
Yes.
Okay. Okay. And then can you tell us a little bit about, I mean, I think you understood that, no, she wasn't supposed to have unsupervised visits, correct?
Yes.
Can you tell us a little bit like what made you allow that happen?
Just Evelyn had missed her Johnny and her cousins and the mom and wanted to spend time with them that weekend. So I did allow that one time for her, and then one time was at her house. So one time was at Johnny's house for the weekend, and then one Saturday only was at the apartments here with her mom.
Okay.
She
And
brought
so,
her back that Sunday.
so the one time at Johnny's was like Friday to Sunday, is that correct?
Yes.
Okay. And then so I heard some testimony that Evelyn came back dirty. Can you tell us about that?
On the last visit when she stayed at her mom's apartment, she didn't come home dirty. Her hair was just knotted up, wasn't combed.
Okay. Okay. So at this point, Ms. Spray, do you have any concerns about Sydney's ability to take care of Evelyn unsupervised?
No.
Okay. Your Honor, I pass the witness.
Okay. Anybody else have any questions, Miss Spray?
Yes, Your Honor, I do.
Okay, Miss Potts.
Ms. Spray, how many times have you paid the rent or paid part of the rent, because we don't have a full accounting here, for Miss Sydney?
I would say probably twice.
So you've paid full rent
I mean,
twice?
I
Okay,
paid half, like some of it.
Lies.
Okay.
So I
Lies.
paid her
Lies.
deposit. I paid her $450 deposit to move in.
okay,
And then I paid just partial of her rent. That's it. This one was because she had missed work, we're assuming, because she works at Airbnb, so we gave her that concession.
okay. Did you personally you paid your deposit? What else did you personally pay? I think you said you paid twice.
I paid like half of rent. I don't even remember how much I paid.
Okay, 2 times is correct.
Yes,
That's what I'm
yes.
remembering too. Can you get us please a full accounting? Not right now, but when you
Okay,
get it.
yes. Mhm.
Okay, okay, thank you. It is my understanding that you also allowed, you took Evelyn to visit Dad at his house in Kingsland. Is that correct?
But we went and picked him up. It was my mom's 80th birthday. We all went to eat in Marble Falls with my mom and my sister and Luis. So he
Okay.
went and ate dinner with us in Marble Falls.
Okay. And he still had on ankle monitor, is that correct?
Yes, he got permission to go
Okay.
since it was her birthday.
So why did you allow that when you knew she wasn't supposed to be seeing him and his rights were terminated?
I just did. I don't know why. She loves and misses her dad.
Okay.
And he's not going to do anything when I'm there with her. I didn't take him home. My sister did. Evelyn and I left the restaurant together, and he went home with my daughter.
Okay.
My daughter.
So Ms. Spray, in the past, you've indicated to us that, we have allowed for Miss Sydney to come by your apartment complex and visit with Evelyn. Is that correct?
And y'all have allowed her to? Yes, y'all have told her to.
Right. Has she
Yeah.
come by to visit her during that time when you have her?
No,
Not once?
no.
Okay.
Unless y'all tell her to, she will. She never comes from her free will to come visit her or call her or anything like that.
Okay. Does she provide anything for her in terms of
Hey.
clothes or food or anything?
No.
Okay.
And going back, it's not Sydney's. Sydney did not ask Evie to go the weekend. I'm the one who asked Sydney if she can come for the weekend. Sydney never asked her to. It was on me.
Okay. And isn't it true that you also told me that those things had occurred? You were honest about that with me. Is that correct?
I'm sorry, I didn't.
I said, I wanted to clarify too, that you were honest with me about those visits having
Yes, I
occurred after when I asked. Okay.
Yes.
Okay. And you also indicated to me that when Evelyn came back from Sydney's, her hair was matted up. It didn't look like she took a bath. She had circles under her eyes, and it
Yeah.
didn't look like she slept. Did I have that correct?
Yes.
Okay. And it's also my understanding that there is a Mr. Weaver that works at your apartment complex.
Yes.
And can you tell me how he's related to Johnny?
His son is married to Johnny.
Okay. And isn't it true that you have also told me that Mr. Weaver has indicated that they party at Johnny's all the time and that's where Sydney stays?
Do I have to answer that?
Yes, ma'am, you do.
Sometimes he has.
Okay. So you were aware of the alcohol and the parties and Sydney staying over at Johnny's?
I need to know what this other lawyer is gonna clap back with, right? This is not good.
Yes, I'm aware of that.
And yet you still allowed Sydney to take Evelyn for the weekend over to Johnny's?
Yes, that was my decision, not Sydney's.
Okay.
Sydney has never asked to see Evelyn, so I'm the one who asked her.
Do you have a concern that I know there was, going back, Sydney wasn't showing up to any extracurricular activities until we kind of really encouraged her to go. Is that correct?
Yes.
Do you have a concern about Sydney not really wanting to go to extracurricular activities and not coming to see Evelyn when she can come by any afternoon and not calling her? Does that cause a concern to you?
Oh, yes. I mean, she's these last 2 weekends, she has tried calling Evie, but I'm not allowing that anymore because she had a whole year to do that and has never did anything to go out of her way to see Evelyn. So I'm not allowing her now to call and see her.
Well, those phone calls would be allowed.
But I don't have to allow that. I don't have to.
Okay.
I don't have to let her talk to her mom.
Okay.
Oh,
So,
oh boy, this lady is digging herself in this huge hole. Monica, thank you so much. I will. I absolutely will. I, I don't know what happens with this lady and this judge, but this lady is deciding on her own which of the judge's orders that need to be followed. And I'm scared for her right now. This judge is going to murder her.
The other question is, if she has never come by, why hasn't she ever come by the office? Did she indicate to you why she didn't come see her daughter?
No.
Does Evelyn know?
Yes, I tell Evelyn.
You tell her what?
I say that that her grandma doesn't call her. Evelyn wants to call them. I do not allow her to call them because they don't even call her and ask for her. They don't come and see her. Nobody reaches out to call about Evelyn. Nobody does on her side of the family.
Okay.
And I do let Evelyn know that.
Okay, Judge. You can see our dilemma. No further questions.
Thank you. Anybody else have any questions, Ms. Spray?
I've got one or two, Judge.
Okay, Mr.
Hi, Ms. Spray. My name is Rob Wilson. I represent CPS in this case. How long has Evelyn been placed with you?
For almost a year.
And how's that been going?
At first it was really hard, but it's gotten a lot better.
Tell me about what was hard.
She was just way behind in school. She didn't know how to write, read. She was just having trouble wanting to do homework, just typical 8-year-old. She's gone to counseling, so basically she has the mind of a 5-year-old, but she's 8. So it's just getting her to kind of catch up to her age.
Okay.
There's a lot of baby talk. We're trying to get her out of baby talking. She's missed a lot of those years. So she's a little bit behind. So that's kind of, that was a struggle.
Yeah. And it's gotten better though, you said,
Oh, yes. Mhm.
but she's still with you all the time. Is that correct?
Yes.
Do, have you ever talked to anybody about taking a break now and then, what we call respite care, something like that?
Yes, I just started to with Marcy.
Okay.
Yeah.
And is Marcy going to work on that for you?
I hope so.
Okay. Okay, good. Do you understand everybody's concerns here, Ms. Frey,
Yes,
about contact that's not been approved?
I
Do
do
you?
now.
You do now?
Yes.
Can you explain to us your understanding of what the concerns are that everybody has in this case about Evelyn's safety?
Yes.
Is it, do you believe Evelyn's safe with you?
Yes, I do.
Do you believe Evelyn was safe with Sydney when she was with her?
I do. She loves her daughter. I'm sure. I believe she wouldn't let anything happen to her daughter.
Okay. But you also realize we're here because of choices Sydney made, correct?
Yes, I understand.
Okay. So the people in this case are we want to trust Sydney, but she's kind of got to earn it and got to prove herself with us. And sometimes that means enforcing those rules. Do you understand that now?
Yes.
Okay. I think that's all I've got. Thank you, Ms. Spray. Pass on to Ms. Judge.
Okay, thank you. Anybody else have any questions, Ms. Spray? Ms. Spray, when y'all did this birthday luncheon and took Evelyn to see her dad, is he the same person that came up to your door that you wouldn't let in the house?
Yes. And I still won't do that. Yes. The
Okay.
same person.
Okay, that's what I thought. Okay,
Mhm.
thank you, ma'am.
Mhm.
People in the apartment complex got flood concessions.
Two other people did.
2 others or 2 total?
Two other people. Yes.
Okay, so
I'm talking
3.
three altogether.
Okay. And how many people get a welcome home? Was there a welcome home concession?
No, it's a card. I guess she pays online. So it's called the Welcome Home Card. A lot of our residents pay online instead of coming in here.
Okay,
So
so
you
it's
pay like $30 to use that card. A lot of people do that. I don't know why.
okay. So concession wise, the flood deal was the only sort of rent help the apartment complex gave her. Is that correct?
Yes, we did that with all our facilities. Yes, we did.
Okay.
That was, yeah.
Okay, I understand. Thank you. Okay. Anybody else? No. Okay, thank you. Miss Wright, next witness.
That's all witnesses I have, Judge. I would just, we are asking for unsupervised visits. I know what you said about that. But at this point in the case, we're way far in and she has not gotten to get off unsupervised, even though she's done everything that the department has asked her. So we're just asking for little baby steps so that we can move the case forward, because we don't have real good placement options for these kids, on a long-term basis.
Okay. Has she done a nail test, Miss Wright?
I'm not sure. I know she did a hair test a while back. I'm not sure, Judge.
Right, Miss Dale Cruz, has mom done a nail test?
I'm looking, Judge.
Anybody know? I don't remember. I didn't get a call for her.
Judge, I don't believe we did. She said her nails were too short, and then I don't think it happened, unless Sydney remembers. She may
She's
remember.
trying to say something.
It looks like in November of 24, there was one done and that was a negative. I have a couple hair tests.
Okay.
So it's been a while since she's had a hair or a nail.
Okay.
And Judge, I would ask for ETG on that. That seems to be the issue.
Okay. I don't think that ETG can be told in the nails.
I think it's hair, right?
I don't know. I don't know. But if it can, I want it.
Okay.
Pretty please. And Your Honor, Miss Evans is going to have to leave pretty soon, and I did want her to talk about Jordan, if we could do that.
Okay, we'll go take her out of order. Okay.
Miss Evans, can you please turn on your camera and unmute yourself? I know you're juggling another child there.
Yes.
Okay, can you tell us about Jordan's behaviors and special needs, just very general overview for the court so that the court and the lawyers understand?
Yeah, Jordan has significant sensitivities to transitions. He's easily overwhelmed, especially with loud noises or sensory input. He has really difficult time socially, so he's not able to build relationships, communicate his needs effectively with peers, and he has a difficult time communicating his needs. So what happens is that he gets overwhelmed, and it will start small potentially, where there's just like chronic noise, screaming, falling out on the floor, and
I'm
it can
overwhelmed.
escalate to him being really aggressive. He's hit teachers in the face repeatedly with blocks, ripped his pull-up off, screamed and yelled. He'll hit, kick, bite other kids. We've had days at school where we get reports every hour that he's assaulted someone, he'll also punch himself in the face and headbang when he gets extremely dysregulated. He'll go periods of time where we just see the tantrums and we're able to mitigate any aggression by using a weighted vest, giving him visual prompts for the schedule, putting noise canceling headphones on him, and really like containing the environment at home. But then when there's changes in his routine or difficulties that he's not able to manage, we'll see periods where he has this spiked aggression. So over the holidays, when there was lots of changing because of routines, he had a lot of aggression. And then since the middle of June, we've seen a spike in his behavior. The school writes reports daily and have a lot of concerns about their ability to manage him. And there's two pieces to the school issue, just for clarity. One piece is that Jordan is currently a basic level of care. It's my understanding if we were to have him reevaluated and he was placed at an appropriate level of care, which would be moderate or specialized, he'll lose his daycare funding completely, and we can't afford to bridge that gap. So what we're asking for is a commitment that even if we stay in CCS, that no matter what level of care Jordan is assessed at, that he's able to continue to receive daycare funding. And then the other piece is that even with CCS, I've not found a daycare that's adequate to meet his needs. I do have him pending a special education evaluation with Georgetown ISD, where I'm hoping he'd be able to enter, but the soonest they said would be January, and that's if he's still with us. Otherwise, obviously that would go with him. I also have him on wait lists for evaluations for ABA clinics that theoretically could help to provide some care for him as well. He's been in speech and occupational therapy and play therapy since we've had him in October. He did successfully complete occupational therapy, but will likely need to be reassessed when he hits kind of that next milestone to see if he's still making adequate progress.
Judge, that's all I had for Ms. Evans. I just wanted to give everybody an overview so they understood the seriousness of his needs and level of care.
Okay, I have a bunch of stuff written down about that, and Ms. Potts, let me know. I mean, for the order today, Ms. Potts, let me know if I need to order anything else.
Yeah, Judge, I'm thinking if I know Ms. De La Cruz is going to look for that daycare, but if she, if she's unable to find options, like if he's discharged today or tomorrow, we might not have options. And I think that's the concern because Ms. Evans works and also takes care of another child in her home. So if we could go ahead and have the order that just says if Ms. De La Cruz is unable to find it, that we could go ahead and put in place the special daycare, I would appreciate it.
I mean, I think his level of care needs to be reassessed.
Yes, Your Honor, it does. We need to go ahead and do that.
ASAP, here's just what I have. ASAP, CPS must pay for and provide for his child care with no gap in time. Disability specialist needs to be assigned to this case also ASAP.
Yes, Your Honor, I think Ms. De La Cruz has already talked to the disability specialist as well as the social security specialist, and they're working on what they're working on.
Okay. Anything else to help Ms. Lacey?
Ms.
Or
Lacey, do you
last
need
response?
anything? Ms. Evans, do you need anything else?
I don't think so. We've got him in therapy services. We're able to meet his needs at home. The biggest concern is just his needs being met consistently in a school environment where he's not increasing his frequency of aggression. He's starting to mimic other kids' behaviors as well. And I worry that he won't lose those behaviors and it'll just get worse if we don't intervene to not only, I think the point of the CCS daycares, there are a lot in the area, but they'll have 2 or 3 openings. The ones that have consistent, they'll take all CCS kids, just will not be safe for Jordan. He also has the elopement issues, and we've had some issues with their supervision of him as well. So anything we can do to get him an environment with a lower ratio, I greatly appreciate.
Okay, come on.
Ms. Evans, have you checked out Head Start around your area? Was that an option?
Head Start has limited hours. They have the same ratio of 1 to 15. The school that I'm proposing for Jordan is 1 to 5. With that level, him with 14 other kids, so he sits at tables by himself, he plays by himself, and he does that on purpose because he gets so overwhelmed. When you put him with other kids, he'll start swinging his elbows and then escalate to punching and biting. He needs space and a quieter environment.
So I also added, let's see, CPS, the child care is to be an environment with lower ratio and safe for Jordan. CPS is to confer with Georgetown ISD about his needs. Okay.
Thank you, Your Honor.
And report to the court and all attorneys CASA within 1 month. Okay, got that. Okay, thank you, ma'am, Ms. Evans. You stay on until you're able to leave if you would like. Let me tell you.
Yes, ma'am.
Okay, okay.
Thank you.
Okay, thank you. Okay, Ms. Wright, do you have any more witnesses?
No, Judge, thank you.
Okay, Mr. Grove, any witnesses?
No, ma'am, other than to ask Mr. Oliva to respond to the letter that I just mailed him.
Did you write that to Llano County?
Yes, sir, I did.
Okay, I haven't got it yet, but when I get it, I'll respond to it immediately.
Yes, sir, thank you.
Okay, thank you. Okay, Mr. Clyde, what would you like to add?
We saw the dad.
Your Honor, I think you guys have covered a lot of material, and I agree with all the comments that were made today. The concerns I have are current placement for Jordan and safety, not so much the placement itself, but his ability to receive the services that he needs in the daycare that would be good for him. The recent psychological evaluation of him pointed out the autism level 2 diagnoses and the delayed development. So it's important that he gets that. As has been discussed, his behavior since about mid-June has deteriorated as he moved up to an older class in the daycare that he's currently at. So that disruption has not been good for him. And then for Evelyn, just the concerns, just to reiterate the concerns about the unsupervised visits that occurred. And but she seems to be doing well. She just started the new school year. She was happy to get back into the classroom to see her friends again. So all of those things have been addressed at this point. So I have nothing further.
Okay, thank you. Ms. Potts?
Your Honor, I believe that is all that I have, but I do believe that adequate time is being provided. It is just that Ms. Lewis is not taking advantage of that, and that seems to be a pattern unless we mention it in court or we're on her case every day about going to an extracurricular activity or the court orders it. She just doesn't do it, and that is concerning.
Okay, I have a whole page of orders. Let me ask this. Do y'all think we need to go on a reset mediation? Because our next permanency hearing is 10/21, and then our trial is 11/12.
Yes, Your Honor, that would be good.
Okay. And who, I don't remember, did y'all went to mediation before? Do y'all want the same mediator or you want somebody different?
I don't think we've mediated this.
I don't
Okay.
remember.
Yeah, I
I
don't think
was just about to say that I missed it.
Okay.
Matt, it's old age.
I confess that fully. I'm still caught up on the beer party and the free rent.
Yeah, yeah. Okay, let me look at something.
Judge, I wouldn't want to do it too soon because, you know, if our trial's not till November and our dismissal date is December, there's a lot of time for potential improvements or I guess lack thereof.
Well, I have, excuse me, between 10/21 and 11/12. But
I
since
think
that's a short time frame, y'all need to go and get it on the books.
Yes, ma'am. No, that's great. Thank you.
Do we need to do in person?
Yes, Your Honor, I think that would be good.
Okay. And placement of 10.
That would be good too.
Okay, mediators, Russ Baker, Fran Brockstein, Angela Dabo, Emily Miller, Carl Pro, Randy Robinson, Andrew Thompson, Sonia Camp, Matt Camp, Gary Cooley, Dory Mystic, and then I have another former judge that wants to get on the list, but she wants to Zoom. So
Emily? I don't know. It's
Yeah, I only
complicated.
know half of those people but the half I know would be fine. Emily would do a good job.
y'all, Ms. Wright, you okay with Emily Miller?
Yeah, I think that would be fine.
I mean, you got Mr. Baker?
But wasn't he mom's attorney?
Oh, yes, he was. Yes, thanks. Sorry. Forgot.
That's who I was thinking of.
Yeah.
But yeah, I think Emily will be fine.
Mr. Grove, opinion?
Judge, nobody really ever cares about my opinion, but to the extent the court does this morning, I'm fine with that also, Judge. I assume mediation will be at the courthouse there next to the barbecue places.
Well, there's not a barbecue place next to the courthouse, but it'll be somewhere.
Well, it's close enough for a fat guy like me, Judge.
Yes.
I'm trying to get to the important part of mediation for that.
It's in the same town. That'll do.
That is the important part.
And it's not like it's in the same town in Austin. So yeah, you can probably get to it in 5 minutes. You'll be okay.
I don't even like confessing that I live anywhere near Austin, Judge.
Okay. So here's the orders. Parents shall have a service plan. You have to comply. Your rights can be subject to termination. Our next permanency hearing is 10/21/25. Let's see. Paternal grandma is not to assist parents in any manner financially, not through her job, not paying rent, nothing like that. She is not to allow the parents to have any contact with the children except as told to her by CPS or the advisor. Mom is not to receive credit for any classes until successful course completion is verified by CPS. No sample certificates accepted. Provide CPS with contact information from CPS to be able to verify the completion. CPS, daycare, school specialist to help Jordan's foster family ASAP. CPS is provide child care assistance for Ms. Spray and respite immediately. Ms. Sydney can attend Evelyn's extracurricular events if Ms. Spray is attending. Ms. Sydney is to nail test with results returned by 9/15/25 per CPS. Sydney is to successfully complete a PETH test as arranged by the department before 8/20/25. Jordan's level of care is to be reassessed ASAP, and CPS must pay and provide for his child care with no gap in time. Disability specialist on the case also to be assigned ASAP. Jordan is to be in a child care with lower ratio, and it's safe for Jordan and meets his needs. CPS is to confer with Georgetown ISD about his needs, report to the court and all attorneys, and cost it within a month. Anybody need anything else?
Judge, I believe we may need a standalone order if the department has to pay for the daycare with the lower ratio. I don't think they'll do it without it.
Well, somebody just send me one.
Yes, ma'am.
Okay.
Can we circulate that order before it's sent to you, Judge, please?
Yes, it's a lot. Yes. And I'll
And,
take a copy of the stock exchange and send it to y'all.
and Judge, what did you order has to be done by 8/20/25?
Test. It's an alcohol test. Everybody knows about it.
Thank you.
I'm taking a picture of it right now. Okay. Okay. Good luck to everybody. And yeah, she can go to extracurriculars, but Miss Placement has to be there, and she's not to be alone with her. And Placement has to be right there also.
So Judge, is your order no unsupervised or no unsupervised unless agreed by the ad litem's and department?
My order about visitation is as y'all agree.
Thank you.
Okay. With the exception of attending extracurricular, like open house, you know, she has like soccer game, whatever, she can go to those things with Miss Spray attending and close by.
Thank you.
Okay, thank y'all. Y'all excuse.
Okay. She's taking a picture, guys. Leave her alone. Leave her alone. All right. Next, we're going to finish up in Maricopa. We haven't been there, I don't know, in a week or two, at least.
Hearings in your CR 2025 matter in the, on August 12th at 8:30 and August 14th at 8:30, both in the downtown Maricopa County Superior Court. In your failure to appear matter, I am setting a secured appearance bond in the amount of $500. Now, you are also here because you were arrested yesterday on charges of possession of dangerous drugs, a Class 4 felony. I did find probable cause for that. In your new matter, I am...
They did find probable cause? There was no probable cause. Somebody lied and said I was talking crap to somebody in the street. I was shaving my head. Okay. They pulled up on me and lied. There's no probable cause. There's no probable cause. They walked up and said the same thing that they said the last time I was here. Somebody lied and said something about me, and they arrested me. They're harassing me, dude.
Okay, so I did find probable cause for possession of dangerous drugs.
What probable cause did you find for them to go in my pockets, though?
Okay.
Because you're on their side. Fuck you.
I am appointing you an attorney. I am setting 3 hearings in your case. The first on August 12th at 8:30. The next one on August 13th at 1:30 p.m. and the last one on August 14th at 8:30 a.m. all in the downtown Maricopa County Superior Court. Because you were on release, is he still in the room or did they take him out?
He's been taken out.
Okay. Can we move Mr. Inch? We'll finish him as a house call. I will be finishing Mr. Inch's matter as a house call this evening, but I'll go ahead and finish putting it on the record. Because Mr. Inch was on release in his case CR 2025-125407 on the date of the offense for his new charges, I am holding him non-bondable on his new matter. All right, we're going to move on to Stephanie Lewis. And then after Ms. Lewis, we're going to do Landon Morrison. All right, Ms. Lewis, go ahead and state your name for the record.
Stephanie Lewis, 31191.
Thank you. And you are here on 3 matters this evening. We're going to go ahead and start with your probation matter. You are currently on probation in CR 2017-102627. In that matter, the Maricopa County Superior Court issued a warrant on allegations that you violated your probation. I am in that probation violation matter. I am appointing you an attorney, and I'm setting hearings on August 13th at 8:30 in the downtown Maricopa County Superior Court. In that matter, I am setting a secured appearance bond in the amount of $500. Now, you are also here because The Maricopa County Superior Court issued a warrant for your failure to appear in your matter CR 2025-117395. In that matter, I'm not appointing you an attorney because one should already have been appointed for you in that matter. You can always retain an attorney at your own expense to represent you. I'm setting hearings on August 12th at 8:30 and August 14th at 8:30, both in the downtown Maricopa County Superior Court. In that matter, in your failure to appear matter, I am setting a secured appearance bond in the amount of $500. Finally, you are here because you were arrested yesterday on charges of control of, hold on, let me get this, let's see, Form 4, give me just a second. Unlawful control of or theft or unlawful control of a means of transportation, a Class 5 felony, and possession of drug paraphernalia, a Class 1 misdemeanor. I did find probable cause for both of those violations. I am appointing you an attorney. I'm setting hearings on August 12th at 8:30, August 13th at 1:30 p.m., and August 14th at 8:30, all in the downtown Maricopa County Superior Court. Because you were on release in your case CR 2025-117395, that's the failure to appear case, I am holding you non-bondable on your new charges. All right, go ahead, step to the left, officer has your paperwork. All right, Landon Morrison, please, and then Samuel Stinnerson.
Hello, Jan.
Hi, Mr. Morrison, go ahead, state your name for the record.
My name is Landon Mark Morrison, 33097.
Thank you, and you are here this evening because you were arrested earlier today on charges of possession of a weapon by a prohibited person, a Class 4 felony, failure to admit carrying a deadly weapon, a Class 6 felony, and resisting arrest, causing risk of physical injury, a Class 6 felony. I did find probable cause for those. I am appointing you an attorney. I am setting hearings on August 12th at 8:30 and August 14th at 8:30, all in the downtown Maricopa County Superior Court. In your matter, I am setting a secured appearance bond in the amount of $15,000. Yes, sir.
Are you saying that I can't leave it without $15,000?
So it is a secured appearance bond. You can work with a bonding company to get that amount posted.
Okay, I have a question on it.
Yes, sir.
If you can just hear me out, please, briefly.
Okay, I am going to remind you, you have the right to remain silent. Anything you say could be used against you.
Yes, ma'am. I understand the probable cause and everything you find. I also wanted to say that the initial interaction, I was asking the officer for help, and he came with his light and started looking in my car. That's how everything unfolded. I'm also asking you, please, to consider, ma'am, I have been doing good for 4 years. I've been clean. I got off fentanyl meth. I literally worked from the ground up, Your Honor. I have my car in the parking lot out there. I have a full-time job at Big O for 2 years. I've been doing good, paying all my stuff like 10P, showing up to things on time. I just ask and pray, would you please, 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 Your Honor, give me an opportunity with the OR. I will, even if it's a week. I just have my car, and Tempe literally, or Scottsdale literally told me that they would leave it over last night. They took my keys and my wallet. It's not even my property here. I have no way to release anything. I would very greatly appreciate and give you my word to show up, Your Honor, even if it's a week. I just want to get everything in line, please, and thank you.
I appreciate that, and I do see that it has been.
It's been so long. I've been doing so.
It has been. It looks like your last conviction was in 2019.
I didn't even know the law, man.
That being said, you're a prohibited possessor, and you had a loaded gun in your car.
No.
So based upon that, the prohibited possessor thing is taken very seriously. That is a very serious offense. Based upon that, I am leaving that $15,000 secured appearance bond set. I did read the Form 4. I did consider your history.
Right. May I, the last thing I'll say, I appreciate your time and even listening to me. Basically what I'm saying is, the probable cause is beginning to get to all that. Did you happen to consider that? Because there was no call,
So
anything.
if you want to raise the fact that your contention is that it was an unlawful search, I did appoint you an attorney, and you can talk to your attorney about that, and you can raise that. But for purposes of tonight's proceeding, I am finding probable cause. All right, go ahead, step to the left. Officer has your paperwork for you. Samuel Stinnerson, please, and then Zachary Roselle. All right, Mr. Stinnerson, go ahead, state your name for the record.
Yeah, it's Samuel Stennerson,
Mr. Stinnerson, what's your date of birth?
December 5th, 1992.
Thank you. And you are here this evening because you were arrested earlier today on charges of aggravated assault, class 6 felony, tampering with with evidence or attempting to destroy or alter evidence, a class 6 felony, disorderly conduct, class 1 misdemeanor, and assault, class 1 misdemeanor. I did find probable cause for all of those. Based upon the information that you provided to pretrial services, I am finding that you are not indigent, so I am not appointing you an attorney. However, you may, of course, retain an attorney at your own expense to represent you. I am setting hearings on August 12th at 8:30 and August 14th at 8:30. Both of those are in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in your matter in the amount of $10,000. In the event that you are able to post that bond and secure your release, you would be subject to certain release conditions, including not returning to the scene of the alleged crime or have any contact with any alleged victim. You would also be subject to ankle monitoring. I understand that this was your house where this happened. I am specifically stating in the order that you may not reside at the same location as any alleged victim or go to the alleged victim's residence, even if you are an owner or renter of the residence. If you presently reside with any alleged victim, you must find an alternative residence. You can arrange for one civil standby to collect any essential belongings. Okay? Go ahead, step to left. Officer has your paperwork.
Thank you.
Zachary Roselle, please, and then Olof Westland. All right, Mr. Roselle, go ahead and state your name for the record.
Zachary Garrett Roselle,
And Mr. Roselle, which date of birth?
09/29/1982.
Thank you. And you were arrested earlier today on charges of taking contraband into a correctional facility, a class 2 felony, possession of narcotic drugs, a class 4 felony, driving with a suspended or revoked license, a class 1 misdemeanor, and knowingly displaying a false license plate, a class 2 misdemeanor. I did find probable cause for all of those.
Guys, if you're gonna break the law, don't break the law. If you're gonna smuggle something into the prison, don't have drugs on you. If you're gonna have drugs on you, don't drive. Don't drive illegally. If you're gonna break the law, don't break the law. You're gonna get caught for one of them.
I'm appointing you an attorney.
Yes, ma'am.
I am setting hearings on August 12th at 8:30 and August 14th at 8:30, both in the downtown Maricopa County Superior Court.
Sorry, I apologize. May I ask what the first one was?
Taking contraband into a correctional facility.
They had searched me already on that.
They did.
I didn't
search you.
I didn't have any, but yeah, I thought that was taken care of. Because they pulled all my pockets out, and if I knew it was there, I would have, said, hey. So I'm not trying to argue anything. I'm just trying to be fair.
Okay, and I understand that. But it looks like once you were taken into the Mesa jail, they did an additional search of your person. They found a micro baggie containing white substance, and this was
that was the same search when they found out.
Sir, this was after you were taken into the Mesa jail. And then you said those weren't your pants. And it was
no, but they'd already, yes, ma'am. They'd already pulled everything out 3 times.
All right.
So I thought they had it.
And I am appointing you an attorney. You
Yes,
can make
ma'am.
all these arguments to your attorney.
Yes, ma'am.
All right.
Thank you.
And I am setting court hearings on August 12th at 8:30 and August 14th at 8:30, both in the downtown Maricopa County Superior Court.
Yes,
I am setting a secured appearance bond in the amount of $10,000. All right, go ahead, step to left. Officer has your paperwork.
Yes, ma'am.
Aluf Westland, please. And then
These aren't even my
Jorge
pants.
Heredia. All right, sir, go ahead, state your name for the record.
Alof Westland. You almost had it.
I have honestly, this first time that I've tried to pronounce that name, so sorry. Alof. All right, sir, what is your date of birth?
12/15/1964.
Thank you, and you are here this evening because Maricopa County Superior Court issued a warrant for your arrest on allegations that you violated your probation. In your case, CR 19999096181. In that probation violation matter, I am appointing you an attorney, and I'm setting hearings on August 13th at 8:30 in the downtown Maricopa County Superior Court. Pursuant to that arrest warrant, I am setting a secured appearance bond in that matter in the amount of $5,000. In the event you are to post that bond and secure your release, I'm reminding you, you need to contact your probation officer within 72 hours. All right, go ahead, step to the left, officer has your
What date
paperwork.
was that court hearing again?
August 13th at 8:30, but that information will be in your paperwork.
Thank you.
Thank you. Jorge Heredia, please, and then Selma Phillips. All right, sir, go ahead, state your name for the record.
Jorge Heredia,
And what is your date of birth, sir?
09/05/2001.
All right, and you are here on two matters. You were arrested earlier today on unlawful flight from law enforcement, a Class 5 felony, and obstructing government operations, a Class 1 misdemeanor. I did find probable cause for those. I am appointing you an attorney. I am setting two hearings in your case, the first on August 12th at 8:30, and the second one on August 14th at 8:30, both in the downtown Maricopa County Superior Court. In your new matter, I am setting a secured appearance bond in the amount of $1,000. In the event you are to post that bond and secure your release, I am requiring that you register with pretrial services. They will do things like remind you of your upcoming hearings, okay? Now, you are also here because Tolleson Municipal Court issued a warrant for your arrest on, it's a pre-adjudication warrant, so it would be a failure to appear warrant in their matter involving criminal trespassing. And in that matter, I am setting a $50 secured appearance bond. And so I am appointing counsel for purposes of, for limited representation regarding the bond issue only. I am setting a hearing on August 11th at 8:30 in the Tolleson Municipal Court. Again, if you're able to post your bonds and secure your release, you will need to go to that hearing as well. All right. Information regarding your hearing dates and times will be, along with your bonds, will be in your information, and the officers have it for you if you go ahead and step to your left.
Thank you.
Thank you, sir. Selma Phillips, please. And then Naomi Charlie. All right, Ms. Phillips, go ahead and say your name to the record.
Stolen Phillips, 8483.
All right, and you are here today on two matters. Maricopa County Superior Court issued warrants for your arrest on allegations that you violated your probations. In your case of CR 2018-135993 and CR 2022-133758. In both of those probation violation matters, I am appointing you an attorney, and I'm setting hearings on August 13th at 8:30 in the downtown Maricopa County Superior Court. In your 2018 matter, I am setting a secured appearance bond in the amount of $1,000. In your 22 matter, I am setting a secured appearance bond in the amount of $250. In the event you are able to post your bonds and secure your release, I am reminding you, you need to contact your probation officer within 24 hours. All right, go ahead, step to left. Officer has your paperwork for you. All right, Naomi Charlie and then Karen Jumper. All right, Ms. Charlie, go ahead, state your name for the record.
Naomi Shannon Charlie.
All right, Ms. Charlie, what's your date of birth?
March 23rd, 1985.
Thank you. And you are here this evening on two matters. We're going to go ahead and talk about your new case first. You were arrested yesterday on charges of possession of dangerous drugs, a Class 4 felony. Did find probable cause for that. I am appointing you an attorney. I'm setting hearings on August 12th at 8:30 and August 14th at 8:30, both in the downtown Maricopa County Superior Court. In your new matter, I am setting a secured appearance bond in the amount of $750. Now, you are also here because
A probation violation.
Yeah, hold on just a second. Yes. So it is, it's a warrant for a probation violation out of the Peoria Municipal Court. In that matter, I'm indicating that an attorney should be appointed for you at your next hearing because I'm setting a secured appearance bond in the amount of $50 and counsel is appointed for limited representation regarding the bond issue only. I am setting a hearing on August 12th at 9 a.m. in the Peoria Municipal Court.
All right.
All right, go ahead, step to left, authorize your paperwork. All right, Karen Jumper, please, and then Cynthia Vella. All right, Ms. Jumper, go ahead, state your name for the record.
Karen Lynn Jumper.
And Ms. Jumper, what's your date of birth?
10/2/53.
Thank you. And you are here this evening because Maricopa County Superior Court issued a warrant for your failure to appear in your matter CR 2022-104504. In that matter, I'm not appointing you an attorney because one should already have been appointed for you, but you can always retain an attorney at your own expense if you choose to do that. I am setting a hearing on August 12th at 8:30 in the downtown Maricopa County Superior Court, and I am setting a secured appearance bond in the amount of $500. All right, go ahead, step to left, authorize your paperwork for you. All right, Cynthia Vella, please, and then Cameron Crawford.
So,
Hi, Ms. Vella, go ahead, state your name for the record.
Cynthia Maria Vela,
And Ms. Vella, what is your date of birth?
December 23rd, 1979.
Thank you. And you are here this evening because the Maricopa County Superior Court issued a warrant for your arrest for failure to appear in your matter CR 2024-141241. In that matter, I'm not appointing you an attorney because if you are eligible to have an attorney appointed, one should already have been appointed for you. You may always, of course, retain an attorney at your own expense to represent you. I am setting hearings on August 12th at 8:30 and August 14th at 8:30, both in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in this matter in the amount of $500. In the event you all post this bond and secure your release, I'm reminding you need to go to your hearings. All right, go ahead, step to the left.
Ma'am, if I wanted to self-bond, can I do that today?
I'm sorry, what?
So there was a bond for the amount of 500?
Yeah, so you can post your bond, and then you would be able to secure your release.
So how do I do that after this?
So officers can give you information about how that process works, okay?
Okay.
Okay, go ahead, step to left.
Thank you.
Cameron Crawford, please, and then Jose Gutierrez. All right, Mr. Crawford, go ahead, state your name for the record.
Cameron Crawford,
And Mr. Crawford, what's your date of birth?
March 6, 2000.
Thank you. Mr. Crawford, you are here this evening because the Maricopa County Superior Court issued a warrant for your arrest on allegations that you violated your probation in CR 2024-104300. In that matter, I am appointing you an attorney, and I am setting hearings on August 13th at 8:30 in the downtown Maricopa County Superior Court. I am setting a secured appearance bond in your matter in the amount of $250. In the event you are able to post that bond and secure your release, I am reminding you, you need to contact your probation officer within 72 hours, all right?
Okay.
Go ahead, step to left, officer, as your paperwork. Jose Gutierrez, please, and then Shawnee Guasola.
Gutierrez?
All right, Mr. Gutierrez, go ahead, state your name for the record.
Jose Gutierrez,
And Mr. Gutierrez, what is your date of birth?
11/9/1992.
All right, you are here this evening because the Maricopa County Superior Court issued warrants for your arrest. In your case, it's CR 2022-000541. CR 2023-104764, on allegations that you violated your probations in both of those cases. In both of those matters, I am appointing you an attorney, and I am setting hearings on August 13th at 8:30 in the downtown Maricopa County Superior Court. In your 22 case, I am setting a secured appearance bond in the amount of $100. In your 23 case, I am setting a secured appearance bond in the amount of $100. In the event you are able to post your bonds and secure your release, I am reminding you, you need to go to your hearings and you need to contact your probation officer within 72 hours.
Okay.
All right, go ahead, step to left. Shani Quizula, please.
It's okay, Judge. It's okay. Listen, take a break. Take a break. You've been working hard. All right, guys. We did it. We made it to the end of this stream. I did try to set up the OJ stream, and it just sort of created a second of this stream. So I decided not to touch anything after that because I didn't want to break this stream. So OJ's not set up, but it will be very shortly. I shall see you all again very soon. You're not going to be redirected because it's not even set up yet. Today's Saturday. So go out and do something today. I have like an art show, a big festival art fair that I'm going to. I saw other people are going to festivals. Go out and do something fun today for a few minutes and put pictures in Discord. I'm going to put pictures in Discord. Probably of food. At an art show, I'm going to put pictures of food. Food is art. Thanks, guys. I'll see you all again soon. Bye. Oh, wait.
Coffee wakes up every day. Moon still glows, no delay. Streaming chords before sunrise. Coffee not yet in our eyes. Yesterday's joy or sorrow. Caffeine makes bright tomorrow. Screens light up like the sun. Day with her's always fun. No matter the season, caffeine's a reason. Morning in full swing, with the joy she will bring. Early bird catches the tail. Caffeine's dreams never stale. Sip our Joe and just a light. Caffeine's magic feels so right. She's up the light morning, all the world adorning. With her smile so wide, takes us on a ride. No matter the season, caffeine's a reason. Morning in full swing, with the joy she will bring. Yesterday's joy or sorrow. Caffeine makes bright tomorrow. Screens light up like the sun. Day with her's always fun. No matter the season, caffeine's our reason. Morning in full swing, with the joy she will bring. Early bird catches the tail. Kathy's dreams never stale.